The law office of Selwyn D. Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the bankruptcy code.
This is Selwyn's Law. Every week at this time, we get to hear from Selwyn Whitehead. She's not just an attorney at law. Selwyn knows her stuff and doesn't shy away from the truth, even when it's ugly. Her Bay Area practice focuses on helping her clients to manage their wealth through estate and tax planning, to managing their debt through reconstruction or bankruptcy. And now it's time for Selwyn's Law.
Welcome to Selwyn's Law with award-winning bankruptcy attorney Selwyn Whitehead. Hi, Selwyn.
Hi, Clifford. How are you doing?
I am just so good today. How are you?
I'm great, thanks.
How was your Thanksgiving?
Oh, like too much.
And that's something I think many of us relate to. Selwyn, last week, simply fascinating talk you were giving on estate planning and particularly trust. Can you pick things back up for us? Maybe a little bit of a summary and then just pick things up for us.
Sure. I was sharing with our wonderful audience that you break estate planning up into two parts. One, the part where you're doing the plan, and the second part is where you're implementing the plan after the planner has said bye-bye to this universe and gone on to the next. So I was talking about the tools. A will is a tool that you could have, and if you have a will, that's going to be probated through the court, meaning that a petition has to be filed with the probate court in state court, and then there's a process through which you would have to go through to get the court to sign off, appointing the executor to be the person that's going to administer the estate, and every step of the way is something that has to be signed off by the court until the assets are fully distributed. The next tool in the toolkit is a trust. And a trust is a vehicle where the trustors, the settlers, the grantors, that's a synonym for the entities or the individuals that set up the trust. And that's done outside of court. And you get to allocate how the assets are going to be held while the parties are still alive. And then what's going to happen when the first of the parties dies, if there's a couple. There's a whole process you go through. But basically, a trust is a contract that can, for the most part, be executed outside of the probate process. But I also cited a couple examples where you might want to have the authority or the approval of a judge when you want to do something that's a little bit different, or the circumstances are such that you want to cut off the statute of limitations for filing claims. So let's talk a little bit more about trust. There's different kinds of trusts, two major kinds. There's a living trust, also known as a revocable trust. A living trust is an inter vivos trust. That simply means that the trust is created while the grantor is alive. There are many different kinds of living trusts. So, for example, a qualified personal residence trust where you put your house into a trust, irrevocable life insurance trust, charitable remainder trust, grantor retained annuity trust. Most people using the term living trust mean a revocable trust created for the benefit of the grantor during his or her or their lifetimes, with the remainder interest in family members or loved ones. The grantor typically is the trustee and beneficiary during his or her lifetime, but they have the ability to revoke the trust while one or both of the original trustors are alive. Now, so since early 1980s, revocable living trusts have become increasingly popular as a planning tool here in California. Today, in fact, most professionally prepared estate plans for people with significant assets include a living trust. I remember my professor saying, because I went to law school after I graduated and got a master's degree in tax law, and my emphasis was estate planning as well as federal taxation. And at the time, since people started using revocable living trusts in the 80s, most of the original batch of people that used these tools, they're still alive. And I remember my professor saying, we don't know what's wrong with the plans that have been implemented, but I'm sure we'll find out after people die, and there will be a lot of litigation. And so we're starting to see some litigation now. So There can also be a trust that's created in your will, a testamentary trust. That's a trust that you would say you want to put your assets in a trust, and that's part of your will. But however, a will is not effective until admitted to probate and signed off by a judge. So a testamentary trust can never benefit the grantor except that it makes sure that his or her wishes are fulfilled. So the difference between a testamentary trust is a trust that comes alive once you die. A living trust takes place while you're alive, and you're the original trustor, trustee, and beneficiary. So what happens when a married couple here in California have a living trust? So there's one trust. Both parties have the ability to revoke it, amend it, change it. But after the first party dies, the one trust splits into 3 different trusts for the most part. The first trust, because we're a community property state, Trust A is the survivor's trust, and it consists of the surviving spouse, 1/2 interest in the community estate, and 100% of the surviving spouse's separate property. The second trust will be something called a credit shelter trust, and it will consist of the first party to die's estate up to the amount that's applicable to an exemption that makes sure that they don't have to overpay taxes. And then the remainder of the assets go into a third trust called a marital trust, and that consists of the amount that's more than what's needed for the applicable exemption. So what am I talking about, this exemption stuff? Say there was a $2 million estate. So that would mean that both parties had $1 million. When the first party dies, the $1 million would not be taxed to the first party's estate because it would go untaxed to the spouse. But when the second spouse dies, say the amount that was shielded from tax was only $1 million, upon the second spouse's death, the estate would have to pay tax on half the estate. So a way around that is to put the first party's property in another trust that will not have to be taxed. So you really need to have an attorney help you with this because the tax laws change periodically, and you want someone to be able to not only do this, but articulate to you why they're doing this. Okay? And then so the surviving spouse has access to all of the property, and the trust will be set up such that he or she can use it while they're alive, but the second and third trusts become irrevocable for tax purposes. The spouse can do whatever she or he wants with his own property and even change the beneficiaries. But the idea is to protect the B trust and the C trust from taxation. So, how much time do I have?
You still have a couple of minutes. I know there's a lot of stuff you want to cover, and I want you to cover more of it. Maybe we even take this into another week.
Yes.
Is there a threshold, though, of how much money or how much you need to have before you consider a trust as opposed to just a will?
You know, that's a good point. And so it's like bankruptcy. There's no cookie cutter. Every case is different. If you're a young person just out of college with a huge amount of debt and no job, you just need a will so you can make sure that your baseball cards go to your best friend. But say, you come out of college, you get a great job, and you have children right away, or you know that you're ultimately going to inherit Aunt Sally's estate because you're her favorite and you've done everything you could. So circumstances change, but as you grow into your late 20s and 30s and you start a business and you're successful, you need to think about a trust. I think everybody needs a will because you just want to tell people what it is that you want to do. And when we come back next time, I'm going to talk about a tool that we can use to make sure we don't hurt anybody's feelings unintentionally. That is to say, do what's called an ethical will, where we record by videotape and explain why we did some of the things that we're doing. That might be able to be used as evidence to prevent someone from suing the estate. And it also can be a tool to let people know that it's not that I hate you. I just didn't think that you could do with this money. And so I'm going to do this, or I want this other person. This other person needs this more than you do. So we can talk about that next time.
Real good. Well, I look forward to that. If someone wants to get in touch with you, what should they do?
They can give me a call. I'm at area code 510-633-1276, or they can email me at selwynwhitehead@yahoo.com or Selwyn@selwynwhitehead.com.
That one's my favorite. Selwyn, thank you so much. We'll talk to you again next time with more of Selwyn's Law. Thank you for taking time to listen to Selwyn's Law. Remember, the Law Office of Selwyn Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the Bankruptcy Code. When it comes to your finances and your rights, seek no other than the Law Office of Selwyn Whitehead. Selwyn is your go-to finance attorney, specializing in estate planning, wealth management, bankruptcy, tax, and real estate law. In other words, Selwyn knows her way around the dollar, and your rights are protected by our laws. Protect your money, know your rights. Partner with Selwyn Whitehead. For immediate assistance, or if you have questions, call 510-633-1276, 510-633-1276, and go to selwynwhitehead.com. The preceding paid program is sponsored by the Law Office of Selwyn Whitehead, who is solely responsible for its content. The Law Office of Selwyn D. Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the Bankruptcy Code.